Hello and welcome to the Minimum Competence episode for Monday, November 3rd, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have a solo SCOTUS debut, FBI infighting over jet use, and a court order forcing the Trump administration to resume food aid during the shutdown. Let's remember, November comes and November goes, with the last red berries and the first white snows, and read today's legal news. On this day in legal history, November 3rd, 1884, the U.S. Supreme Court decided Elk v. Wilkins, ruling that Native Americans were not automatically U.S. citizens under the Constitution. The case involved John Elk, a Native American who had left his tribal affiliation and tried to register to vote in Omaha, Nebraska. He argued that by assimilating into American society and residing outside his tribe, he had placed himself under U.S. jurisdiction and thus should be granted citizenship under the 14th Amendment. The court disagreed, holding that Native Americans born into tribal nations were not, quote, subject to the jurisdiction of the United States in the sense required by the 14th Amendment unless naturalized through an act of Congress. This decision legally excluded Native Americans from the rights and protections afforded to other Americans, including the right to vote and equal protection under the law. It reinforced a system in which Native identity and U.S. citizenship were treated as mutually exclusive. While the Dawes Act of 1887 later allowed certain Native Americans to obtain citizenship by accepting land allotments and assimilating, this was a piecemeal and coercive process. True universal birthright citizenship for Native Americans was not granted until 1924 with the passage of the Indian Citizenship Act, which declared all Native Americans born in the U.S. to be citizens. The Elk decision underscores the deep contradictions in American legal history regarding sovereignty, race, and citizenship, and it illustrates how constitutional protections were unequally applied. It remains a key moment in understanding the legal marginalization of indigenous peoples in the United States. Daniel Ginsburg, a solo practitioner based in New Jersey, will argue his first case before the U.S. Supreme Court on Tuesday, going up against renowned litigator Lisa Blatt. Ginsburg, who runs his practice with just a laptop and Dropbox, turned down offers from major law firms, including Blatt's own, to retain control over the case and seize the rare opportunity to appear before the justices. His case centers on a procedural issue: whether a default judgment entered against his client, Coney Island Auto Parts, by a Tennessee bankruptcy court should be vacated due to lack of personal jurisdiction. The underlying dispute involves a $48,696 debt related to bankruptcy proceedings filed by Vista Pro Automotive in 2014. Ginsburg argues that the judgment was void from the start, but the Sixth Circuit denied relief, ruling his client's challenge came too late, a position that conflicts with other federal appellate courts. This circuit split helped pave the way for Supreme Court review. Ginsburg, who emigrated from the former Soviet Union and graduated from St. John's School of Law, took the case on a contingency basis after years of litigation. Despite the steep odds and high-profile opposition, he has spent months preparing, including mock arguments with law professors. Blatt, representing the bankruptcy trustee, argues that Ginsburg's client had years to object and failed to act in time. Ginsburg remains focused on the procedural integrity of the system, saying his motivation is simple: I want to win. Yet, even if successful, the case could be remanded for further proceedings in a bankruptcy court. FBI Director Kash Patel forced out a senior official, Stephen Palmer, who oversaw the Bureau's aviation operations, shortly after online scrutiny emerged over Patel's use of an FBI jet to attend a personal event. Patel's trip to State College, Pennsylvania, where his girlfriend, country singer Alexis Wilkins, performed the national anthem, was revealed through publicly accessible flight data and Patel's own social media posts. Following the media attention, Palmer, a 27-year FBI veteran and acting head of the Critical Incident Response Group, or CIRG, was told to resign or be fired. Though FBI directors are required to use government aircraft for security reasons, the optics of Patel's travel sparked criticism, especially given his past remarks condemning similar behavior by former directors. Palmer's firing marks the third leadership ouster within CIRG under Patel, reinforcing a pattern of high-level dismissals since his appointment. His predecessor, Brian Driscoll, is among a group of former officials suing the administration for alleged retaliatory terminations tied to perceived political disloyalty. The FBI's leadership page now lists Kevin Kowalski, previously head of the San Juan office, as the new CIRG chief, a change that was reportedly planned before the jet controversy. Patel's spokesman defended the director's travel practices as compliant and cost-conscious, dismissing criticism as politically motivated. A federal judge in Rhode Island has ordered the Trump administration to immediately resume food assistance payments under the Supplemental Nutrition Assistance Program, or SNAP, despite an ongoing government shutdown. Judge John J. McConnell ruled that full benefits must be paid by Monday, or at the very least, partial payments must begin by Wednesday. He criticized the administration's refusal to use $5.25 billion in congressionally approved contingency funds, calling the decision arbitrary and emphasizing the irreparable harm caused by payment delays to millions of low-income Americans. The administration had claimed it lacked authority to distribute the funds during the shutdown, which began on October 1st, But McConnell rejected this argument. He noted that Trump himself had previously issued guidance during his first term stating that contingency funds could be used in such scenarios. In a Truth Social post, Trump said he does not want Americans to go hungry and directed his lawyers to seek clarity on funding SNAP legally, which the judge cited approvingly in his order. In addition to the Rhode Island case, another federal judge in Boston ruled similarly in a separate lawsuit brought by 25 Democratic-led states and the District of Columbia, saying the administration was wrong to assert it couldn't use contingency funds. The USDA previously warned it may not have enough money to cover November benefits, which cost up to $9 billion monthly. Judge McConnell suggested the agency could also tap into a separate $23 billion fund if needed. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment and leave a rating or review on your podcast player, we'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, this is the month of nuts and nutty thoughts. That November, whose name sounds so bleak and cheerless, perhaps its harvest of thought is the richest of the year.